Welcome to Lunchtime Law on the Margaret McLean Show. I'm a former prosecutor, civil trial attorney, and law professor, and this is where we take the legal stories dominating the headlines and translate what is actually happening inside the courtroom. Please subscribe, press the like button. I'll be following these cases happening right here in my state of Massachusetts, and some are happening right here in my county of Plymouth. You can find me right here every weekday at noon. It's usually live, but today I'm helping out with a fishing tournament on the Cape. So it's pre-recorded, but I'll be able to join the chat. So chat away. I'm not in my studio today, but I'm covering the motion to dismiss brought by Karen Reed and Aidan Kearney, Turtleboy, against the plaintiff, the House defendants, for defamation. So what I've done is put my law professor hat on. I've made some graphics so you guys can understand what 12B6, a motion to dismiss, is at this stage. And I'm also going to get into the anti-SLAPP statute, and I've made some graphics on that too. And then we'll get into the video of what happened yesterday with my commentary for the motion to dismiss. So the defendants in this case, Karen Reed and Aidan Kearney, through their attorneys, filed a preliminary 12B6 motion to dismiss the complaint. Basically, what they're saying is the complaint itself fails to state a claim upon which relief can be granted. So even if all of the factual allegations are true within the complaint itself, the plaintiff has not established a legally valid cause of action. Here I'm explaining what the anti-SLAPP statute actually means. It works as a legal shield to protect citizens, advocates, and whistleblowers. It stops people from using a frivolous lawsuit, somebody who is trying to exercise their rights to free speech, or if they're engaged in petitioning the government. So that's what Turtleboy and Karen Reed are claiming they were doing. They were exercising their First Amendment rights to petition the government. That's why this case should be dismissed. And that's what the attorneys are arguing. The central issue surrounding this motion to dismiss is what counts as petitioning activity. What statements are petitioning activity, or what statements were meant to harass the plaintiffs? For example, statements made during a lawsuit, on the witness stand, or argued by the attorneys during a trial or to investigators, those have protection. Those are petitioning statements. Statements made at a town hall, school board meetings, zoning board hearings, protected. But here's where it gets a little gray. Statements to reporters, on podcasts, to the media, or, for example, what about Karen Reed's statements to the documentarian doing that documentary, The Trial of Karen Reed? So that's where we have a little bit of a gray area. Are those statements petitioning in this case? Are they intended to influence a police investigation or public corruption or a court case? Or were they statements meant to harass these plaintiffs? That's what the court will be deciding. The court must vet every statement here. Check this out. So we have a major burden shifting. If the judge rules that Reed and Kearney's public accusations were a form of government petitioning, then we have a burden shift to the plaintiffs. So we'll have to see what the judge decides. This clip is about Aidan Kearney. The plaintiff's attorneys are arguing that he engaged in harassment, yet Aidan's attorney claims otherwise. So take a listen and then ask yourselves, is this activity petitioning the government, or does it amount to harassment? Here we go.
A governmental body in this petitioning activity. And one fact that I think is important here is that of all the activity he engaged in, all of which was, in our view, non-petitioning and not intended to reach the government or designed to reach the government, when he had an opportunity to petition the government, he declined to do so. And we think that's an important and objective indication that his intent was not to reach the government. In fact, his intent was to attack and defame private citizens.
So, Attorney Klein, what do you say to the relevance of the Fifth Amendment? There is no relevance to the invocation of the Fifth Amendment because he's being sued for his statements that he made well outside of the courtroom. Those statements were petitioned. The suggestion that Mr. Kearney did not intend for his message about Karen Reed's innocence and the plaintiff's guilt to reach the government is belied once again by the allegations of the amended complaint. They admit that Mr. Kearney was responsible for the hundreds of people who showed up at the Dedham courthouse every day during that trial to protest. Who were they protesting? They were protesting the prosecution of Karen Reed. Who was prosecuting Karen Reed? The government. Mr. Kearney is clearly the leader of the national Free Karen Reed movement. And what do the words Free Karen Reed mean? What do they signify other than a demand, a petition that the government do something or stop doing something? That's what he did. Obviously, his words you reach the government. You have in the record, early on, some of his Canton cover-up stories, a directive to his readers. Email Michael Morrissey at mmorrissey@state.ma.us. That's in one of the very first Canton cover-up articles. He says repeatedly that our presence protesting and doing standouts is intended to let the government know that we are watching and that we will not let an innocent person be railroaded. The anti-SLAPP statute doesn't extend just to speaking in court or petitioning the government directly as in filing a police report. It extends, and I know that Your Honor knows this, to statements that are reasonably likely to enlist public participation in an ongoing judicial case. I would submit that Aidan Kearney successfully enlisted the greatest degree of public participation in a judicial proceeding in the history of this Commonwealth.
I think it's interesting because the judge asks, what about those witness intimidation findings against Aidan Kearney, where Judge Doolin and Judge Krupps found that his statements were outside the protection of the First Amendment and amounted to actual witness intimidation. So let's take a listen here and tell me what you think about that.
And that, not to get off the topic of Your Honor's question, but the commercial motive that we'll get to that. Okay.
So Attorney Manning, you want to tell me why Judge Doolin and Judge Krupps' statements are relevant?
So, Your Honor, Judge Doolin and Judge Krupps' findings that Mr. Kearney's activity was outside the protection of the First Amendment because it was activity that was intended to intimidate witnesses and harass witnesses is important because it provides you with some insight as to how other judicial officers considered whether or not that type of conduct was constitutionally protected and therefore likely to be petitioned. In fact, what Mr. Kearney has done and what Ms. Reed has done by conspiring with him is pursued an unlawful campaign of harassment and intimidation, and a tool that they used in connection with that campaign was defamation. And so this, I think, the findings of Judge Krupps and Judge Doolin really just point to a truism. And that truism is, in the history of the United States, there has never been a case that we can find in which the court ruled that one citizen may publicly accuse another of murder outside of any reporting to government and be immune from civil liability for it. There's no case, Mr. Pyle has not cited any case. It would be a radical expansion of anti-SLAPP protections for this court to find that. And that is highlighted by Judge Doolin's and Judge Krupps' conclusions that what Mr. Kearney was doing with respect to these witnesses, and again, I think it's important to separate what we alleged in the complaint, which has to do with conduct directed towards these witnesses, versus other conduct he may have been involved in, relating to the DA or the investigation or whatever it may have been. What we've alleged is, of course, conduct directed at these witnesses. What Judge Krupps and Judge Doolin analyzed was the conduct he directed at these witnesses, and they found that there was no constitutional protection for it, which is exactly what we are saying in this case, that there was no constitutional protection for his defamatory and harassing conduct. The defamation here being in service of an effort not to petition the government, but an effort to intimidate and browbeat these witnesses into changing their testimony. And we make a specific allegation in the complaint in that regard, where Mr. Kearney says, this will all stop if you flip. He's not petitioning the government to get these witnesses to flip. He's petitioning the witnesses themselves, and he's encouraging others to intimidate them in order to create that outcome for misreading.
So, Attorney, along that issue, it would appear that your position is that the anti-SLAPP statute and the cases interpreted precludes someone who has been publicly accused of murder by Mr. Kearney from prosecuting an action such as this.
I'm sorry, Your Honor, I don't understand the question. Preclude,
Well, put another way, how can publicly accusing someone of murder be petitioning activity?
oh, easily. It depends on the context in which the statement is made. And I will have to say regretfully that the plaintiffs have broadly overstated the law about this. They say on page 20 of their brief that the law is clear that accusation of criminal conduct is only petitioning if made to the police or other law enforcement agency. That's on page 20 of their brief. There has literally never been a Massachusetts case that has said that. They cite 4 cases in support of that assertion, but none of them say that. And, of course, reports to the police are petitioning, but that doesn't mean that reports that, a statement that the police are investigating the wrong person, who the police should be investigating, are these plaintiffs, Brian Albert, Brian Higgins, Jennifer McCabe, Colin Albert. They should be investigating them. And the fact that they didn't even consider investigating them shows that this police department is corrupt. That's been Aidan Kearney's thesis throughout this entire time. In a footnote in their brief, I note that the plaintiffs concede that generally raising awareness about police corruption is and can be protected petitioning activity, they say, but they draw this distinction. Accusing people of murder can't be petitioned. In this case, they are all part of the same ball of wax, because the reason that Aidan Kearney believed that Trooper Proctor and the other investigators were corrupt was because they didn't even consider investigating the people at 34 Fairview on that night question. Instead, they decided to protect, he said, a Boston police officer and other powerful people in Canada. The corruption is bound up inextricably with the allegation that plaintiffs were responsible for this murder and not Karen Reed. The North American Exposition Company case says that in deciding whether statements are petitioning, you must look.
So this part is interesting. The judge cites 2 cases as to whether this activity was in fact petitioning. Let's take a listen to this.
Well, let's talk about context for a second, because many of Mr. Kearney's actions could be interpreted as seeking to make the plaintiff's lives miserable. In fact, he says something where he said, somewhere, I forget where I read it there, but they'll never live a normal life. The plaintiff cites Judge Salinger's decision in Clay Court versus Colton for the proposition that Kearney trying to plaintiffs for punishment is not petitioning activity. What's your response to that?
The motive behind petitioning activity, once you establish that it constitutes petitioning activity, is irrelevant. And I would suggest, Your Honor, that it's helpful to look at these allegations on a count-by-count basis. That is what Bristol Asphalt instructs must be done. The defamation count.
You all did that in submission.
Well, I would respectfully say we did it better than they did. But on the defamation count, Your Honor mentioned earlier that reviewing the complaint is the first step in deciding what a claim is based on. That entire claim is set up at paragraph 156 in repeatedly publishing false statements asserting or reasonably understood to be asserting that the plaintiffs were responsible for the murder of O'Keefe and a cover-up of their purported role in the murder. Kearney published numerous defamatory statements. That is and then they list the harm and the fault and all sorts of other things that they say provide the foundation of the defamation claim. Absent from that is any allegation that he set out to make their lives miserable. Absent from that is any motive allegation, which isn't relevant in the anti-SLAPP context anyway. The statements that plaintiffs were responsible for the murder were part and parcel of his petitioning about the corruption of the case and everything else. That is what the defamation count is based on. And clearly, we say all the counts are based solely on petition. But plainly, we say right there in paragraph 156 that that's the foundation of the defamation complaint. So anything else?
You asked him earlier, why would accusing a private citizen of murder be petitioning activity? And he said, oh, easily. And then he didn't cite a single case in which that has ever been found. That accusations against another citizen, not funneled to the government, not a police report, not a tip to the FBI, not using an intermediary to inform law enforcement that somebody's committed a crime, just speaking it, that another citizen has committed murder falsely, as you have to presume in construing our complaint. He says easily that's petitioning activity, and yet nowhere in the history of the Republic, as far as we can tell, has any court ever concluded that. In fact, to the contrary, we cite cases where Attorney Pyle says petitioning activity is found where citizens report criminal conduct to law enforcement. But in those same cases, and I would urge you to consider Bowman, which is a First Circuit Court of Appeals case, those same cases acknowledge that the reporting of criminal activity to law enforcement is petitioning activity, but then reporting of it to third parties is not. And in that case, the plaintiff was somebody who had been accused of sexual assault. The accuser had previously made a complaint to the FBI and another governmental agency. Subsequently, she informed people with whom that individual was doing business of the same complaints. And the First Circuit concluded that while the earlier reports to law enforcement may have been petitioning activity, the reports to third parties were not. And here's the kicker. The reports to the third parties were to staff of congressmen. And even there, the First Circuit held that that was not petition. And there are other cases that we cite in which wrongdoing is reported outside of governmental channels and not given petitioning protection.
That's a pretty relevant case right there that was cited. So I think the judge will talk about that, it will be part of his decision. Very interesting.
I want to talk about Attorney Pyle's comment about context, that it's important to consider context. They cite North American expositions for that principle. We cite it as well. The context that the court was considering in North American expositions wasn't the political climate. It wasn't the overall course of conduct. It wasn't, some atmospheric assessment of what was going on in the world. It was the context of the forum in which the statement was made. And there, the forum in which the statement was made was to the South Boston Community Foundation, which was created by the legislature, placed in the executive branch, and responsible for distributing public funds. And that was the context that North American expositions, which they cite, concluded was an appropriate forum in which petitioning activity occurs. Here, what they are encouraging you to do is say, Judge, consider the gestalt of what Mr. Kearney was involved in. Consider that he was in, as a general matter, using his YouTube page and his for-profit entity to talk about issues. That's the context in which you should find that his accusations against private citizens of murder were petitioned. No, that's not what the cases say. The cases say, the North American expositions in particular says, that when considering context, it is the forum in which the statements are being made.
Next, we have a good question about posting to social media. So I think this is very interesting, especially in our modern day, right? So let's take a listen to the judge's question first.
And it's supposed to go to any statement reasonably likely to encourage consideration or review of the issue. The language goes on, but how is posting to social media or encouraging people to participate in a rolling rally at plaintiffs' homes the type of public participation contemplated by the statute?
There have been a number of anti-SLAPP cases that have turned on use of social media to inform and mobilize other people. I had the very first one. It involved the plan to build a racetrack in the Plain Ridge Casino, and the Superior Court there held for the first time that posting on Facebook is protected by the anti-SLAPP statute. Posting on social media is the way today in which people connect with each other. Aidan Kearney has done that to great success in getting people involved in these issues. Indeed, posting on social media and posting on the internet generally, I would point out, is what led your affiants Rita Lombardi and Paul Cristofaro to do things that are clearly public petition. Going to Canton Town Meeting, going to the State House. Mr. Kearney, by the way, the suggestion has been made Mr. Kearney never petitioned the government on its own, but they have alleged in their amended complaint that he was there protesting at the Devon Courthouse. He was also up at the State House protesting to get the Attorney General involved in all of this. He decided that his words, his direct police report from Aidan Kearney to the Canton police wouldn't have done anything. He wasn't a witness to this murder. He reasonably determined that the facts would show that mobilizing thousands of people to protest against this unjust prosecution would be a way potentially to get the charges dismissed as he believed they should have been, by putting pressure on elected officials to do so. That is core
encouraging people to participate in a rolling rally.
The rolling rally, Your Honor, is very much participation in and likely to lead to further public participation. That was a caravan of cars that started in a supermarket parking lot, went to various people's houses, didn't stay for too long, ended up with a protest in front of the Canton Police Department. That is I recognize that he's been indicted for that conduct, but nobody was. It was a peaceful protest in cars, and Mr. Kearney is vigorously fighting, of course, the criminal prosecution for witness intimidation that arises out of that rolling rally. It was also heavily promoted online, such that people who weren't there could see, look, there's lots of other people who believe so strongly in this cause. They're going to go out on a sunny day and participate in a public event. That is also reasonably likely to enlist further public participation by others in this cause. So it is part and parcel of the petitioning activity in the case, and it meets the statutory definitions. Also, he's been sued, once again, for statements accusing plaintiffs of murder, statements that were made in connection with the ongoing criminal case. There's not just one element of the anti-SLAPP definition we're relying on. We're also relying on the statements that, at least during the entire time of the County prosecution, these statements were made in connection with the pending judicial proceeding and were intended to reach the government directly or indirectly.
Let me turn to a few questions relative to the Reed motions. First of all, whenever you start arguing, I don't need to have the party spending the time with 12v6 part. I can review the four corners.
So now we're turning to Karen Reed's motion to dismiss, but we have a problem because her attorney addressed the wrong complaint. He didn't address the amended complaint, so it was a colossal mistake under Rule 9A, and the judge is going to address that, and then we'll hear some arguments about Reed's motion to dismiss. So the judge isn't too happy with Reed's attorney here. So let's take a listen to this.
The June 23rd motion to dismiss simply corrects the caption. But Your Honor, if I may answer the question.
The rule doesn't allow it, does it? Does Rule 9A allow me to send a motion and then a few days later say, I changed my mind, here's another one?
Nothing was changed. We didn't change. No one changed their mind, Judge. What happened was there was an amended complaint which simply adds additional factual allegations. There's no new.
Well, why wouldn't you ask for permission? Why didn't you just do it?
Because we thought we could reasonably deal with counsel. That's why, Judge. And I don't think there's any prejudice to them by getting a complaint.
There's prejudice to the process, and I just don't know. It just seems to me this decision such as that, I don't know whether it's a showing of entitlement or arrogance. I don't know which.
It's neither, Judge. It's simply correcting a motion to dismiss a complaint that was subsequently amended that has absolutely no change substantively, no change in parties, counts, theories, or anything other than additional facts which we address in reply. So it's a correction of the original motion. We reached out to counsel after they pointed it out to us.
They told you they weren't going to accept it.
Well,
So you decided, okay, I don't care what they say, we're just going to do it.
how are they prejudiced? We even offered them more time to respond. It's form over substance, Judge, with all due respect. The arguments are still presented. The theory that they're advancing is still addressed. There's no prejudice, there's no change except some number of paragraphs. And where it said Plymouth, it had said Barnstable because this is where the case originally originated.
This must be so embarrassing for them.
So while I understand the mechanics of the process under 9A, we really haven't violated anything. We've responded to the amended complaint, which is purely an extension of the original complaint. There's cases that hold for that position. It's not an inoperative, superseded complaint. It's an extension of what was initially filed, and we've addressed the arguments.
It was filed as a right. So that's the operative complaint. The amended complaint was filed as a right.
But it still extends what was initially pled at the initiation of this lawsuit, which is a theory that has not changed by virtue of an amendment. What happens?
But actually, the amended complaint addresses different statements made from Karen Reed to the documentarian. So it's actually very important and quite a mistake that he missed this.
In the amendment is some additional factual allegations are included.
So why didn't you respond? Why didn't you address those in your June 23rd? For example,
We addressed in the reply, Your Honor.
right? You could have done it. You could have done it in the amended motion, couldn't you? Because the reply is not to argue stuff you might have missed. The reply is to talk about new stuff.
But we are under no obligation to address every single factual
You're
allegation.
not, but you're also you don't have the ability just to throw in a reply because you want to put in something you might have forgot to address.
The purpose of a reply is to reply to the arguments that are in the opposition to the motion to dismiss, which is what we've done. And I'm here to argue it verbally as well.
You know, the rules are in place for a reason, and all lawyers know that right out of law school. You have to follow the rules.
Let's talk then for a moment about the reference to the statements that Ms. Reed made in 2024 to Mr. Muir.
Yes, sir.
So these statements were made in 2024 to the documentarian when Karen Reed was making that documentary film about her trial. So are these statements considered petitioning the government? So that this will be an interesting argument.
And you address that in a reply. First of all, your reply uses the word allegedly in describing Ms. Reed's words. Do you not concede that she said those things?
Well, the alleged is behind what the purpose.
It says her alleged words. That's what your reply says.
Your Honor, I haven't seen the documentary, so I am responding and advocating for my client's argument. So,
Do you think he should have watched the documentary? I think that would be pretty smart if he's representing Miss Reed.
I'm not going to admit that that's what she said until I've seen it. So for the purposes of argument, I must have used the word allegedly. But the arguments are that that is petitioning activity.
Let's take a look at paragraph 33.
Of the complaint.
If I'm Karen Reed, I wouldn't be too happy with my attorney here, you know, and I take these arguments because I think they're very interesting to listen to as a lawyer and as a law professor and a former civil trial attorney too, because God, if I ever made that mistake, I'd be in so much trouble.
And where she says Jen McCabe is the mastermind of the cover-up, and Colin Albert had motive to kill Mr. O'Keefe. And I use that particular paragraph just as an example. My broader question is, how are Ms. Reed's statements to Mr. Kearney not things the court found, but her statements accusing plaintiffs of murder, petitioning activity? We'll put it another way.
Somebody else or others were. That's in connection with that judicial proceeding, that protected petitioning activity. The complaint rests solely on that type of language. It's also, knowing that Mr. Kearney obviously has a wider audience, is arguably to enlist participation. So at least two statements of the anti-SLAPP statute would cover those statements. From day one, she's taken the position it wasn't her. She was prosecuted twice and acquitted.
Let's go back to a moment if you could to Ms. Reed's.
I think some of Karen Reed's statements are certainly petitioning activity, but the issue is to what extent. I think it will be much easier for Karen Reed because she's involved in, two trials versus Aidan Kearney, but we'll see what the judge decides. And we
Statements to Mr. Muir.
Yes, sir.
She suggested you reply are within the scope of the anti-SLAPP statute. One of the categories being encouraging consideration and review, reasonably likely to enlist participation. So in the criminal trial, the case went to the jury on June 25th, 2024, correct?
Yes.
Okay. 3 days before, on June 22nd, 2024, Ms. Reed gave an interview to Mr. Muir, correct?
Correct.
Let's look at paragraph 97 and 98 of the amendment. And in there, Ms. Reed states, among other things, I know Brian Higgins had a role in helping kill him, helped him get him in the snow, and helped frame Aidan. And then Mr. Muir asked Ms. Reed, you make such strong statements about I think Colin Albert killed him. I don't know how without getting sued, because I don't even know if you're gonna. I hope you're gonna use that. And Ms. Reed responds, if Colin can prove I'm lying, and this is defamatory, he can sue me. So my question is, how can statements by Ms. Reed outside of a criminal trial, 3 days before the case went to the jury, to your own words, documentary filmmakers, that apparently were not going to be released to the public at that time, be considered petitioning activity? Like it's almost the claims and statements to the filmmaker are petitioning activity appears to presume that Ms. Reed was either seeking to influence the jury or she knew it was going to be unjury. How could it possibly be petitioning activity?
Well, firstly, the criminal trial is still ongoing. The jury hasn't got the case yet. The jury hasn't decided. So the judicial proceeding is still ongoing. And if we actually look at what happened, there was a mistrial, which leads to
Mr. Muir to release those statements.
I'm sorry.
The intent was for Mr. Muir to release those statements prior to the jury.
Well, I don't know what the intent was with respect to when this documentary was going to be released.
Sure as hell wasn't going to be released in 3 days, was it?
Well, even if it's going to be released in the future, she ultimately is still in the process of being prosecuted. The trial hasn't ended, it's still under adjudication, it's still a proceeding. These are still statements, these are still protected petitioning speech. regardless of what Mr. Muir's intention was or when he was going to release his documentary. But ultimately, there's a mistrial, and she's tried again and has the same defense, and that leads to an actual acquittal. So this is also to enlist participation. This is also in connection with the judicial proceeding that's ongoing, and therefore falls squarely into the statute's definition.
If it's made 3 days during a pending criminal trial, maybe 3 days before the case is going to go to the jury, and how is it made to enlist public participation?
In the future, because there's, or at the time, it's still part of a judicial. If you take aside the public participation enlistment aspect of the statute, it's still in connection with the judicial proceeding. Whether or not the documentary was published that night, that morning, or 3 weeks from then, it's still in connection with the judicial proceeding. It's still petitioning activity. The statute doesn't say when the judicial proceeding has to have concluded by. It says in connection with the judicial proceeding. Taken to its logical conclusion, it might be that she's even been hypothetically speaking convicted, and she can still say those things and argue it's in the anti-SLAPP statute protection because it's in connection with the judicial proceeding.
So the question would be, are all of her statements constitutional, first protected by the First Amendment and protected by the anti-SLAPP statute? Are they all considered petitioning the government? And that's what he's trying to say.
The plaintiff want to respond?
Yes, Your Honor, I do. What Ms. Reed's counsel has just suggested is that there is no limit. There need be no nexus between what she says and the likelihood or the plausibility that it will reach a governmental body. He just said that even post-conviction, and we actually have allegations that she made defamatory statements, both she and Mr. Kearney, post-verdict. But what they're saying is even post-verdict, because she in the past had been subject to criminal prosecution, she is free to defame people, no matter the audience. Just because she's commenting on somebody else's guilt, not her own, somebody else's guilt. Blakesley says exactly the opposite. Blakesley says that this court is required to assess if a plausible nexus exists, and in doing that, analyze the objective indicia of a party's intent to influence a government proceeding, such as the timing, audience, and content of the state. That's exactly what you were just trying to do here. With respect to the murder allegations, the audience of Ms. Reed's statement to Ms. Murr is not the broad public. She's saying that in a closed private room to Ms. Murr and the small production staff around her. Now, if that statement is later published, she may be on the hook for additional damages. But the defamation that she articulates to Ms. Murr is not enlisting public participation in anything. It is a private statement to Ms. Murr and her small production staff. And as you point out, I think, or I pointed out, the idea that there was a plausible nexus between that statement and something that was under review by a judicial body is so far-fetched as to be totally unreasonable. That statement wasn't going to reach any judicial body. By the way, Karen Reed, if she wanted to reach a judicial body, had every opportunity to do that. Instead, she's talking to a documentarian in private and accusing all of my plaintiffs of murder. Period. There is no nexus to any judicial proceeding. And this does get to the post-verdict statements that we allege she made and that Mr. Kearney has made up until last month. I can touch on that now because the issue of having to analyze whether there's a plausible nexus is one that's going to apply equally to those statements. And what Ms. Reed has argued is that her statements in, I believe, 2026, the Rotten Mango podcast, in which she again defames our client post-verdict. Well, she says, she argues, that has a a plausible nexus to the O'Keefe family's civil case against me, and that by accusing these innocent people of murder, perhaps I can convince the O'Keefe family to drop their case against me. Now, the O'Keefe family isn't a governmental body. They're a private litigant. That's not petitioning activity. And Mr. Kearney equally has a lame excuse for his post-verdict statements, where he says, well, there's the statute of limitations for murder still exists. I can spout accusations of murder into the void, and there's some plausible, some governmental entity will pick that up and then prosecute these innocent people for murder. That is simply not plausible. It's not reasonable. It's an after-the-fact justification that has no support in any of the case law. Go ahead.
Attorney Sullivan, you want to respond?
Your Honor, the seconds are still in connection with the judicial proceeding.
Okay. Attorney Pyle, I guess the characterization would excuse like warrant some response.
Thank you, Your Honor. And I'll note that the argument that was just made, that post-verdict statements can't be petitioning, was not connected to any element of the definition of petitioning in the Anti-SLAPP statute. So I'll read one. Any statement reasonably likely would encourage consideration or review of an issue by an executive body. The Norfolk DA's office still exists. Karen Reed has been found not guilty. If Karen Reed's not guilty, somebody else is guilty. Aidan Kearney fervently believes that the plaintiffs are guilty. It is still possible for them to be charged. In fact, one of the allegedly defamatory statements that they identified in this case is a TV interview that he did, not one of his YouTube videos, but a stand-up TV interview right after the verdict. And Aidan Kearney said, I would hope now that Karen Reed has been found not guilty, we can all unite and demand that the Alberts and the McCabes be charged with the killing of John O'Keefe, because they're the ones who did it. That is a demand on the government to bring charges. It is a statement also that is reasonably likely to bring about further public participation to demand that charges now be brought against the real killers. That is petition.
Attorney Sullivan, didn't give you the chance to argue your motions. What would you like to add?
Your Honor, what I'd like to add is,
Here's the final argument.
without regurgitating what we've already said about the second one of the Bristol assault framework, the sole crux of the complaint, the amended complaint, this lawsuit against my client, is solely based on statements that are petitioning activity protected and immunizing her under the Anti-SLAPP statute. The second prong of the framework requires the burden to shift back to the plaintiffs to show that the statements are devoid of any factual support or any legal evidence. We have put forward enough evidence. You referenced the affidavit and the transcript attached to my declaration affidavit. That's in there. They cited to in our brief. But the facts that established at stage 2 of the framework, most importantly, my client was acquitted of the prosecution's charge that she was responsible for John O'Keefe. The case of Faber versus Walton, the holding was judgment in favor of a party to litigation is conclusive evidence that petitioning activity was not devoid of any reasonable factual or arguable basis in the law. She submitted an affidavit that she did not strike Mr. O'Keefe with the vehicle.
What's the nexus between the finding of the Norfolk Superior Court in a criminal case against one defendant to claims against these plaintiffs?
Because her petitioning speech has to be supported by facts. they have to disprove that there are facts to support the petitioner's speech. So that fact is highly relevant. She didn't strike Mr. O'Keefe with a vehicle. The chief medical examiner, Dr. Irini Soyibello, testified that Mr. O'Keefe's injuries were not consistent with a vehicle strike, but they were consistent with a physical altercation. Mr. O'Keefe did not show signs of that the plaintiffs now have to prove are somehow devoid of proof. So the statements of petitioner, they are covered by the anti-SLAPP statute. The amended complaint rests solely on those statements. And the support for her petitioner activity is factually supported by what I've just read and what I've submitted to the court attached to my affidavit. For those reasons, Your Honor, I ask that the court dismiss the lawsuit against my client and award her attorney's fees as is provided under the anti-SLAPP statute.
Thank you very much. Now you want to respond to.
So the big question is, will the judge dismiss the plaintiff's case here for defamation? We'll find out. It will be a close call, especially as to Karen Reed. I think that as far as most of the statements that Aidan Kearney made, I doubt that I think the case will move forward, but we shall see. And once again, thank you for listening and tuning in to Lunchtime Law. I will catch you tomorrow in a live show. Thank you. Bye-bye.